Please be seated. The sitting is resumed. I now invite the next participating delegation, Namibia, to address the court, and I give the floor to Her Excellency Mokonjo Kapanda Girnus.
Mr. President, distinguished members of the court, I have the honor to appear before you on behalf of the Republic of Namibia in these historic proceedings. Namibia stands before you in fulfillment of our constitutional duty and to advance a core principle of state policy. Article 95 of our Constitution requires positive state action for the maintenance of ecosystems, ecological processes, and biodiversity for the benefit of present and future generations of Namibians. Namibia stands before you to stop the significant harm that climate change has brought to our environment and, in particular, our water resources. The science is undeniable. Greenhouse gases cause rising temperatures and greater evaporation, stretching water resources to their limits while intensifying droughts. With each 1 degree of global warming, water resources could decrease by 20%. For Namibia, keeping the global temperature to 1.5 degrees rather than 2 degrees above pre-industrial levels is a matter of survival. Even if global warming is maintained at 2 degrees, the mean annual temperature in Africa is projected to be 2.3 degrees warmer than in the decade before 2005. The IPCC has highlighted the impact of rising temperatures on water scarcity in southern Africa, including Namibia. Namibia is already the driest country in sub-Saharan Africa and is getting drier still. Currently, 92% of our landmass is classified as semi-arid, arid, or even hyper-arid. Since 2016, extreme droughts have forced the Namibian government to declare a state of emergency 3 times, including as recently as May this year. In fact, we are currently in the midst of the worst drought in a century. Unless we act now, Namibia will become completely arid and enter into a permanent climatological state in which devastating droughts will become a regular feature of life in our country. Mr. President, distinguished members of the court, Namibia also stands before you to protect the human rights of the Namibian people, present and future. As this very court said in 1996, and I quote, "The environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn." Because of the ongoing drought in our country, over 1.2 million Namibians, nearly half of our total population, are currently in a state of emergency and face high levels of acute food insecurity. The loss of water resources is therefore not just an environmental issue, it is a human rights issue that threatens Namibia's very existence and in particular the lives and livelihoods of our people. Finally, Namibia stands before you in solidarity with other African states and small island developing states. Collectively, we are among the lowest emitters of greenhouse gases, yet climate change brings disproportionate harm to our environments, human rights, development, and future generations. In the words of the late President of Namibia, Dr. Hage Geingob, developed nations must provide financial support to enable developing countries to shift to cleaner energy sources without hampering development. Namibia respectfully asks the Court to determine that the obligations of those most responsible for the climate crisis, historically and currently, are not merely aspirational but legally binding, both as primary obligations as well as a legal consequence of violating those obligations. Namibia concurs with the majority of participants that under both questions posed by the United Nations General Assembly, the Court must interpret climate change treaties by reference to international law as a whole. As the Court stated in its 1971 advisory opinion on Namibia, and I quote, "An international instrument has to be interpreted and applied within the framework of the entire legal system prevailing at the time of the interpretation." In the context of the present advisory proceedings, Namibia invites the Court to interpret the climate change treaties in a way that is compatible with states' pre-existing obligations, not only under the law of the sea, as confirmed by ITLOS, but also under international environmental law, international human rights law, and the law on state responsibility. Mr. President, distinguished members of the Court, the Republic of Namibia always appears before the Court with gratitude and confidence, appreciating the role that this august institution has played in our journey to self-determination and national independence. Today, we appear before you as our self-determination and that of so many states and peoples is threatened by climate change. More than ever, the most vulnerable states, peoples and individuals need the protection of international law. More than ever, the international community is in need of the Court's guidance. I thank you for your attention and respectfully ask that you invite Dr. Njodi Donyema to the podium.
I thank Her Excellency Makanjuka Panda Kirnos. I now give the floor to Mr. Njodi Donyema. You have the floor, sir.
Mr. President, members of the Court, it is a special honor to appear before you for the first time and on behalf of the Republic of Namibia. Namibia's submissions on the two questions put before the Court will focus on one issue, a resource that is essential to our very survival: water. On question A, Namibia concurs with the majority of participants in these proceedings that states have legal obligations of mitigation, adaptation, and cooperation in respect of climate change. This is particularly because greenhouse gas emissions, 1, cause significant harm to the environment, specifically the hydrosphere within the climate system, and thereby, 2, has adverse consequences for human rights, particularly the right to water. On question B, Namibia submits that states violating these obligations incur responsibility, including reparations for significant harm they caused to the hydrosphere and the violation of the right to water. Mr. President, members of the Court, turning to the first basis of the legal obligation in response to question A, customary international environmental law, as you heard last week, a minority of participants continue to cast doubt on whether the long-established customary rules, such as the obligation to prevent significant harm to the environment, applies to greenhouse gas emissions. Both ITLOS and a significant number of participants here have already dispelled any such doubt. Namibia adds that these customary obligations apply equally to greenhouse gas emissions, given the well-documented significant harm to the hydrosphere. In Salala, and citing your earlier jurisprudence in pulp mills, you observed that under customary international law, states are obliged in utilizing the international watercourse to take appropriate measures to prevent causing of significant harm to the other party. Furthermore, in pulp mills, you also stated that this vigilance and prevention is all the more important in the preservation of the ecological balance, since the negative impacts of human activities on the waters of the river may affect other components of the ecosystem of the watercourse. In the same way, the best available evidence found in the IPCC's works has incontrovertibly demonstrated that the negative impact of greenhouse gas emissions also affects other components of the climate system, particularly the hydrosphere and the global water cycle. As Ambassador Kapanda Gurnes just laid bare, the catastrophic consequences for climate change in Namibia, if no steps are taken, these will soon result in a permanent state of climatological aridity. We therefore ask, how can this not be significant harm to the environment? Namibia argues that the due diligence obligations of prevention must of necessity anticipate and take into account the impact on the global hydrological system. The customary obligation on states to prevent the significant harm to the hydrosphere due to greenhouse gas emissions is threefold. First, the obligation of mitigation, which means the reduction in greenhouse gas emissions, as already mentioned by other participants. In particular, this entails the obligation of states to regulate the conduct of private persons and corporations and their emissions. Second, the obligation of adaptation. In the context of the hydrosphere, this means increasing the resilience of the water system to the impact of climate change. Finally, the obligation of cooperation. This is a cornerstone to ensuring that the activities of other states are appropriately sensitive to their impacts on the hydrological system. The obligation to prevent harm to the hydrosphere is a global responsibility because the hydrosphere itself knows no national boundaries. For example, because Namibia receives almost a third of its rainfall, of its water, from transboundary rivers, reductions in rainfall in upstream countries like Angola and Zambia will catastrophically reduce water availability in Namibia. As per pulp mills, the obligation of cooperation applies to upstream and downstream states of a particular watercourse. It follows that the obligation must also extend to every state in the global water cycle. Therefore, it is only through cooperation and due diligence in reducing greenhouse gas emissions that the hydrosphere can be protected. Mr. President, members of the court, turning now to the second basis in response to question A, international human rights law. You've already heard about the relevance of the right to life, the right to self-determination, and the right to a clean, healthy, and sustainable environment. Namibia wishes to emphasize that the right to water should not be overlooked by the court's opinion. Water is an essential right to everyone, and this is especially so for the Namibian people and others living in arid areas. We ask the court to confirm that there exists a right to water under both customary international law and human rights treaties, and customary international law as evidenced by state practice and opinio juris, and this is on three grounds. First, the right to water is a crucial component of 1, the right to an adequate standard of living, and 2, the right to the highest attainable standard of health as enshrined in Articles 11 and 12 of the International Covenant on Economic, Social and Cultural Rights. Secondly, the right to water is an integral component of the right to life. This is reflected in Article 6 of the International Covenant on Civil and Political Rights and the Universal Declaration, Article 3, amongst others. Finally, we submit that the right to water is a corollary and an irreducible core of the right to self-determination. This is particularly relevant to states where water resources are crucial to a people's very survival. As a rule of customary international law, the right to water binds each state regardless of its ratification of human rights treaties. This is even more so where the right to water engages erga omnes obligations, such as the right to self-determination. As stated in General Comment number 15 of the UN Committee on Economic, Social and Cultural Rights, the right to water imposes 3 distinct obligations. First, the obligation to respect, which requires states to refrain from interfering directly or indirectly with the enjoyment of the rights to water. Second, the obligation to protect, which requires states to prevent third parties from interfering with the enjoyment of the right to water. And finally, and very importantly, the obligation to fulfill, which requires states to facilitate the enjoyment of the right to water. In the context of climate change, this entails measures similar to those under customary obligation of prevention. For example, states have the obligation to take adaptation measures, of which Namibia has adopted many. States also have the obligation of mitigation in respect of third parties, such as domestic and transnational corporations, within their jurisdiction or control. States must ensure that due diligence throughout the value chains of these business entities, particularly in identifying, mitigating, and addressing the adverse environmental impacts on their business activities. There is only so much that states with low emissions can do, especially with regards to mitigation. Thus, the obligation of high-emitting states, whether or not they are developed or self-proclaimed developing states, is crucial. This brings me to the applicability of the right to water. Mr. President, members of the Court, last week, a small number of participants questioned the relevance and applicability of human rights law Ratione Loci, Ratione Materiae, and Ratione Personae. We will illustrate in turn that none of these hold water. With respect to the application Ratione Loci, states such as Germany have, for instance, questioned the extraterritorial applicability of human rights. Namibia disagrees because, in our view, even though the application of the right to water may differ depending on whether the right holder is within the territory of the state in question, the right to water itself is applicable extraterritorially. This is for 3 reasons. First, the International Covenant on Economic, Social and Cultural Rights contains no limit as to jurisdiction or control. Article 2, paragraph 1 of that covenant requires each state party, and I quote, to take steps individually and through international assistance and cooperation, especially economic and technical assistance, to the maximum of its available resources with a view of achieving progressively the full realization of the rights. This also applies to the right to water under Articles 11 and 12 of the Covenant. In general comment number 15, the committee explained that this requires states parties to respect the enjoyment of the right to water in other countries. Compliance includes cooperation that requires states to refrain from interference, and this includes activities undertaken within the state's party's jurisdiction that deprive another state of the ability to realize the right to water for persons in its jurisdiction. Secondly, to argue that the right to life and other human rights of Namibians and other peoples are inapplicable because they are outside the jurisdiction and control of emitting states is grossly insensitive and self-serving. It is also simply incorrect as a matter of fact and law, as Micronesia this morning and several other participants have already addressed. Finally, insofar as the right to water engages the right to self-determination, the obligation under the right is necessarily owed erga omnes. For these reasons, human rights obligations, specifically the right to water, apply extraterritorially. In any case, the right to water informs the content of legal obligations of states under international law, including international environmental law and the climate change treaties regime. This brings me to the second objection, ratione materiae. In this regard, a handful of participants have also argued that international human rights law does not impose obligations in respect of greenhouse gas emissions, or if it did, compliance with the climate change treaties would be in compliance with human rights obligations. This is also inaccurate for three principal reasons. First, the obligation to respect, protect, and fulfill human rights applies regardless of the source of infringement. Nothing suggests that the protected rights, including the right to water, are to be interpreted restrictively to exclude the infringement due to environmental harm caused by greenhouse gases. In this regard, various courts and treaty bodies have recognized human rights law require states to take measures to prevent such infringements. For example, this year the European Court of Human Rights found Switzerland in breach of its obligations under the European Convention because it had failed to properly implement a regulatory framework for limiting greenhouse gas emissions. Secondly, climate change treaties represent only one piece of a larger puzzle whereby compliance with climate change treaties alone does not ensure compliance with human rights obligations under the right to water. Finally, some human rights, such as the right to self-determination, enjoy preemptory status. As a result, in cases of conflict, obligations flowing from climate change treaties must be interpreted and applied consistently with these preemptory human rights norms. Turning to the final objection, ratione personae, some states have questioned whether human rights law are applicable to future generations, as they regard this to be merely the protection of, and I quote, abstract persons from abstract risks. There is no basis for this argument. The Committee on Economic, Social, and Cultural Rights has noted that compliance with water obligations requires states parties to take measures, and I quote, to ensure that there is sufficient and safe water for present and future generations. This explicitly includes guarding against impinging water in the context of climate changes. Moreover, as already noted by our representative, in your 1996 Nuclear Weapons Advisory Opinion, you recognize the importance of obligations to generations unborn. Namibia submits that states are under legal and fiduciary obligations as trustees for water resources of future generations. Mr. President, this brings me to our final point in response to question B. As a preliminary issue, Namibia adds its voice to the great majority of participants who concur that the Articles of State Responsibility must be followed when determining the relevant legal consequences, including the principle of compensation. Namibia also notes the small minority of participants who have sought to dilute the legal consequences applicable by arguing that the relevant rules and consequences are found exclusively within the climate change treaties regime. In concurrence with most participants, the lex specialis principle finds no application. There is neither actual inconsistency or a discernible intention to exclude the applicability of the law of state responsibility, and this is for three reasons. One, mechanisms such as the Loss and Damage Fund in Article 8 of the Paris Agreement can operate while states seek compensation for the harm incurred as a result of non-compliance by other states with their climate change mitigation obligations. Two, if we consider the travaux préparatoires of the Conference of Parties when adopting the Paris Agreement, they expressly stated that Article 8 of the Paris Agreement does not involve or provide a basis for any liability or compensation. Three, far from exhibiting a discernible intention for climate change treaties to exclude rules on reparations contained in the Articles on State Responsibility, some states have expressly declared that their signing or ratification of the UNFCCC, and I quote, shall in no way constitute a renunciation of any rights under international law concerning state responsibility for the adverse effects of climate change, end quote. Having dispensed with the lex specialis fallacy, Namibia invites the court to affirm that compensation is an appropriate remedy as recognized in Article 36, paragraph 1 of the Articles on State Responsibility. The science of climate change provides ample evidence that anthropogenic greenhouse gas emissions have resulted in the prevailing disastrous climate change events that we're seeing. This has caused huge financial losses and impaired the developmental initiatives of many developing countries, including Namibia. Compensation is of particular importance to developing states that face the prohibitively high costs that are associated with addressing the impacts of climate change and with implementing the projects for adaptation and building climate resilience. Mr. President, members of the court, to conclude, anthropogenic climate change has and will continue to threaten our shared water resources. Namibia has stressed the centrality of the hydrosphere to the lives and